Good evening, and thank you for coming. My name is Jerry Kirshner, and on behalf of the League of Women Voters, we thank you for coming for this evening's program. As part of the League's continuing review of the Champaign County criminal justice system programs and facilities, State's Attorney Julia Rietz will present our program this evening, describing the criminal justice system and pretrial services in Champaign County. The issue of pretrial incarceration was identified as a major factor in the jail population by both the Champaign County Community Justice Task Force and the county's year-long study conducted by the Institute for Law and Policy Planning. Both reports noted that the majority of inmates are being held pretrial. In September 2012, pretrial detainees comprised approximately 80% of the jail's population. Further, ILPP's tracking study showed that the vast majority of offenders committed infractions and misdemeanors and spend less than 3 days in jail. Cycling a high volume of minor offenders at the front end of the system generates a significant waste of staff time and money. Both reports strenuously advocated the development of a comprehensive trial services program in Champaign County as a way to limit pretrial incarceration and reduce jail population, noting that such programs are prevalent throughout the U.S. and used in many Illinois counties. The reports also recommended the adoption of an objective, evidence-based risk assessment instrument when screening individuals for pretrial release and possible conditions of release. We've asked Champaign County State's Attorney Julia Rietz to explain the current criminal justice system and pretrial practices. And so thank you very much for coming. Julia Rietz was elected Champaign County State's Attorney in November 2004 and was re-elected in 2008 and 2012. She received her undergraduate degree in business management and international relations from Boston University and her law degree from the University of Illinois. Julia began her legal career in the Champaign County State's Attorney Office in 1993 as an assistant state's attorney. In 1999, she went into private practice with the Urbana law firm of Beckett and Weber until she was elected state's attorney in 2004. In addition to her duties as state's attorney, Julia is an adjunct professor at the University of Illinois College of Law, where she teaches trial advocacy. She also serves as chair of the county's Children's Advocacy Center Governing Board. Julia lives in rural Urbana with her husband, retired Urbana police officer Al Johnston, 2 daughters, 4 horses, and 4 dogs. Please join me in welcoming Julia Rietz.
Thank you all for coming out tonight and for your interest in this very important topic and for your involvement in our local government system. Today is the last day to register to vote, and my daughter told me when I was on my way over here that at school today, she's 18, and on her birthday I took her immediately to the county clerk's office and had her registered. But she told me at school today that many of her friends were getting registered now on this last day to register to vote. So I was very glad to hear that and wanted to pass that on to you all because I know that is an important part of your mission and involvement in the league as well as in the community. And I appreciate all of the work you all do and the interest that you've shown over the years in the court system, and particularly in the process that we've gone through in the past year or so with the evaluation of our criminal justice system. So I'm here to talk about how things work in our local criminal justice system and give you some thoughts about the pretrial process and what we've looked at and how we've gone through it. I do want to say up front that I'm speaking on behalf of myself, not necessarily on behalf of everyone else involved in this process. I'll try to give you their perspectives if I can, but really my thoughts are mine. And so others involved in the system, the sheriff, the judges, the public defender's office, they've given me some input, but some questions I might not be able to answer because really might be more from their perspective or their decision-making process. And so really I'm going to give you a little idea of how the system works from the prosecutor's perspective, and also, again, talk about the pretrial process and things we've looked at over the past months as we've gone through this evaluation. I have a prepared PowerPoint presentation, which I stayed up really late on Thursday night putting together. But if you all want to go off in a different direction, we certainly can do that. So we're not, tied down to the presentation at all. I'm here to answer your questions, and I'm happy to, if you want to stop and explore a certain area, just raise your hand, jump around, whatever. Just let me know, and we can go off the presentation a little bit. That's perfectly fine. So I wanted to start just kind of explaining the criminal justice system from the perspective of the prosecutor. I always like to start out these talks, whether I'm speaking to a community group like yourself or a group of high school students, explaining that prosecutors have an ethical obligation different from all other lawyers. All lawyers are subject to ethical obligations. The Supreme Court rules set out certain ethical rules we all have to follow, but the only type of lawyer that has a specific ethical obligation only to that particular type of law is the prosecutor. There isn't ethical obligations for tax attorneys or divorce attorneys, just for prosecutors. And Illinois Supreme Court Rule 3.8a says, the duty of a public prosecutor is to seek justice, not merely to convict. And that's a very important principle to me. It's on the wall in my office. It's something that I think guides us. It is not just about convictions. We don't have a score chart on the wall. People don't get compensated based on the number of convictions they've obtained or how many people they've sent to prison or how long or that sort of thing. The goal is to do justice, because the prosecutor represents not just the victim, not just the community, but also those who are accused of crime. We are the government. We have the ability to take away your property, to take away your liberty by incarceration, not in Illinois anymore, in my opinion, thankfully, to take away your life in some states through the death penalty. And as such, we have enormous power, but enormous responsibility as well to exercise that power with restraint, with compassion, with morality, and with an understanding of the interests and concerns of those that we are accusing. And so I really like to start out just putting that out there and saying, this is not just about convictions. This is about doing the right thing. It's about doing justice for all involved in the system. And that really is, I think, what the whole evaluation and review of our criminal justice system was about. It really was an exploration of the system as a whole from the perspective of doing justice for all involved. That was where this process started, from the view of the sheriff and myself and the judges and the concerns that we raised about the state of our jail facilities. These were concerns that we've been raising for years. I, back in 2006, had written a letter to the News-Gazette listing our concerns about the jail back then. And so these are not new conversations, but really from the perspective of doing the right thing. And since 2006, our issues have grown even beyond space issues or beyond having two different buildings to include concerns about the mental health and physical health of those that we incarcerate. As our society has changed, as our financial circumstances have changed, the issues of the mentally ill and the physically ill who we find incarcerated in our jail are much more prevalent, and we'll talk a little bit more about that as we go on. And so again, really the whole process ought to come from the perspective of justice for all involved, as opposed to incarceration or conviction. Okay, so goals of the criminal justice system. Rehabilitation of the offender is a very main goal for all of us involved. Again, this is not just about lock them up and throw away the key. In Champaign County, we have a number of programs going on really focused on rehabilitation of the offender. Our drug court is one example of that. On the juvenile side, we've got Parenting with Love and Limits, our program that we send families to help them learn how to deal with the issues that are facing them today. A lot of programs focused on rehabilitation of the offender, and many things that were recommended in the in the report from ILPP that are going on right now. For example, if you've read in the paper, the county board has just approved funding for a reentry program. That's about rehabilitation and helping people to get opportunities to move forward and, again, continue to become productive members of society. Restoration of the victim and community, a very important goal of the criminal justice system, and sometimes one, quite frankly, that's overlooked. The interests of the victim and the interests of the community in being safe, in being secure in their homes, in their property, in their personal welfare is something that absolutely has to be considered when we're talking about incarceration, when we're talking about our criminal justice system. And in my office, we have a number of individuals whose job is solely to focus on the interests of the victim. Our victim advocates work on a day-to-day basis with people who have been through very difficult, very traumatic situations. And that was probably one of the hardest jobs that I have in my office is these ladies who take care of people who have been traumatized by crime, who've lost relatives and loved ones, who have had to find themselves immersed in a foreign system. Deterrence of others. That is a function of the criminal justice system, and the idea is that if we hold people accountable for their behavior, hopefully others will see that that they shouldn't be behaving that way, they shouldn't be making those kinds of decisions, and they will go forth and make better decisions and be productive members of the community. And punishment of the offender. We have to be honest about it. You know, this is, in our criminal justice system, a part of the process is punishment. We can't dance around it or pretend like it's not. People want to know that if somebody wronged them, that there is some sort of a punishment, some sort of a result that will occur. And that is just a simple fact of our criminal justice system. We can debate all of these things, which is more important, which is less important, but I just wanted to put out there that these are all considerations that, that we have to take into account every day when we're making decisions. And there are no blacks or whites. There's grays throughout our entire system, and a lot of how you see something depends on where you are at in the process or where you sit in the situation. And I'll tell you a little story to kind of illustrate that as we then go on to how we make decisions. And this is true, a true story, a phone call that I received years ago when I was a relatively new state's attorney. I had been elected, but I got a phone call from a gentleman who was very upset because, and wanted to talk to me because his daughter had been the victim of domestic violence at the hands of her boyfriend, and this gentleman, the father, did not approve of this individual at all, and he was very upset. And he wanted to talk to me to make sure that we were going to hold this individual accountable, that we were going to punish him. He wanted him to go to prison. There was no ifs, ands, or buts about it because he had hurt his daughter. And the daughter was not cooperative with us. She was a very reluctant victim of domestic violence, which is normal, very common situation. And so he wanted to make sure, the father wanted to make sure we were going to hold this man accountable, lock him up, throw away the key, et cetera, et cetera. So we talked for a while, and I reassured him we were working with his daughter, and the victim advocate was working with her, and we were taking this very seriously. And he said, okay, so can we change the topic now? And I said, sure. And he said, I want to talk to you about my son. And then he started to tell me about his son, who had had a few too many drinks at a bar and didn't have insurance on his car and had pulled out from the bar on Springfield Avenue. And there was a motorcyclist coming down the road at that time, and there was a collision and the motorcyclist died. And so the son was charged with a felony aggravated DUI. And he was a good boy, and he just made a mistake, and he's, please be merciful, please give him a break, and it was just a striking conversation to me because here was a man with a son and a daughter in two entirely different places in this process, and he was wanting two entirely different things for them. And I just think that really illustrates kind of my point, which is that this is very complex, and there are a lot of grays, and so And so we have to, and actually that gentleman's last name is Gray. And so we have to be cognizant of that and understand that as we move forward and try to work together to solve some of the problems that Jerry so well outlined in the introduction. Okay, a lot of words here. This is just a little explanation of what we do in the state's attorney's office. A lot of words. Primary responsibility of my office is to prosecute state criminal offenses, and that's anything from traffic cases to homicides and everything in between. So regular traffic tickets, your speeding tickets, all that sort of thing, misdemeanor property crimes, thefts, shoplifting, domestic battery, felony theft, burglaries, robberies, drug cases, sexual assault, child abuse, everything, all the gamut of crime, and we see it every day. And I have a lot of wonderful people who work very hard to try to resolve a lot of these very complex and difficult issues. We also, oh, I've got like a little pointer thing. I thought I had a pointer. Okay. We also have, we're in partnership with the Illinois Department of Public Health, and we enforce child support orders on behalf of indigent custodial parents. And that is a very important contract that we have with the state to provide that service. And finally, the less exciting but also very important role, we are the legal counsel for Champaign County, its elected officials, and all departments. So anytime the county is sued, anytime the county is involved in a building project, anytime the county is negotiating labor contracts, my office is representing county government. That can be very complex because oftentimes county government doesn't agree with itself. And sometimes we have to negotiate the differences between elected officials, county board members, and others involved in county government. And so those are basically our responsibilities. And this is just a little layout of my staff. I've got 21 assistant state's attorneys who are divided up between the various departments. We have 13 support staff who are the secretaries who take care of us every day and do a wonderful job. I have an investigator and 4 victim witness advocates. I generally am funded by county funds, but we do have some state and federal grants that support those victim advocates. And we also are responsible for forfeiture proceedings. So when the police arrest a drug dealer and they get lots of money from them, we are involved in the forfeiture process, and we get a portion of the funding from those forfeitures. We do have, as I said, a state's attorney's investigator, and we've had that investigator for a long time. And another positive that came out of the ILPP report and the review of the system has been that the Public Defender's Office now also has a full-time investigator. They did not have an investigator before. They had a line item in their budget to fund private investigator services, but now they actually do have a full-time investigator of their own. And actually, I've been supportive of that request for quite a long time because, first of all, I think it's only fair. Second of all, it helps all of us. If they can have somebody go out and do investigations and gather evidence that helps them, ultimately it can help us resolve cases as a whole. And so that's another positive that has come out of this process. A lot of words again, basically just a little layout of our court system and who does what in the courtrooms. We have 3 felony courtrooms, courtroom A, B, and C, which is Judge Clem, Judge Ladd, and Judge DeFanis. They handle all of the felony cases that come into the county. And basically what happens is they each take a week. So everything that happens this week is going to go to one judge, everything that comes in new next week is going to go to another judge, etc. So they rotate through getting the new cases every week. They also split juvenile delinquency cases between Judge Clem and Judge Ladd. And I have my office arranged so that they are in teams. So each courtroom has 3 attorneys, has 1 secretary, has 1 victim advocate, and they work in a team. And the same with the Public Defender's Office. And so really, we work together well in these teams to keep the process moving. And this is an important point because one of the real positive things about the Champaign County criminal justice system is how smoothly and quickly things move along. Our cases really do move much faster than in a lot of other counties, and I think a lot of that is this system that we have with cases being assigned on a rotating basis and having this team process where our attorneys are working together with the Public Defender's Office to make sure that we're moving our cases forward. We then have Courtroom E, which is Judge Klaus, who handles all the misdemeanors and DUIs and half of our child abuse and neglect cases. Judge Kennedy handles arraignment court, so if you've come in to watch arraignment court, you might have seen that. Judge Ford is our drug court judge who handles that, and Judge Clemens handles support enforcement. Judge McFeeters is down in traffic. And so that's just a little layout of the court system and how it works. So, the next chunk of the talk here is how we make decisions in the state's attorney's office. The most fundamental and important decision that we make, in my opinion, is the decision to charge someone with a crime or to not charge someone with a crime. We, as I said before, are the government. We have that power to take away your liberty, take away your property, and so when we make that decision to bring someone into the criminal justice system by filing charges against them, that to me is the most important part of the criminal justice process. Only the state's attorney has the ability to make that decision. As the Supreme Court said in In re JJ, which is in the middle there, it is the responsibility and duty of the state's attorney and only the state's attorney to evaluate the evidence and reach a determination of whether and what charges may be criminally brought against a defendant. So it's not for the victim of crime to decide whether or not they want charges to be filed. It's not for law enforcement. Police officers can make an arrest and we can decide not to file charges. And so it is ultimately the state's attorney's decision. And in Champaign County, I have on every charging document that gets filed is my signature, because ultimately it's my decision. It might be the decision of the individual attorneys in my office about how to initially proceed, but each one of those decisions are evaluated and approved of either by myself, by my first assistant, or by the lead prosecutor. So it's not just every man for himself, every person making individual decisions. There's a process because they really do need to make sure that they are following my philosophy and making sure that we're being consistent throughout the office. Charging decisions, in my view, must be made with an understanding and a respect for the awesome nature of the power that we have to charge a person with a crime. If we're too vigorous, we might erroneously charge an innocent person. If we decline to charge, a victim might suffer. So we really have to be aware of that awesome power that we have at that initial point. Now, there are 102 counties in Illinois. There are 102 elected state's attorneys. Every county has their own state's attorney. We answer to the voters. We don't work for Lisa Madigan. Some people think that we do. But we each are an individual elected official with our own individual authority. And in 102 counties and 102 state's attorneys, there are probably 102 different processes, because we might share information, we might try to work together, make sure we're being consistent, but every county is going to do things a little differently. And so what I'm telling you is how we do things here in Champaign County. And that's part of the joy, really, of this process, is that we have that individual authority to make sure that we're doing things the way the community that we work for wants us to do things. So, more kind of philosophy, more thoughts about, and law, about the whole decision to actually file charges. As I said, it is not for the victim of the crime to make a decision about whether or not we file charges, and there are many victims that want to give us their opinion. Probably every day there are victims of domestic violence who come to my office and want to drop charges because they've heard that phrase somewhere on TV or someplace else. I want to drop charges. Well, it's not the victim of the crime who decided to file the charges at all. It's the state's attorney. And sometimes that might be a legitimate request with a good basis, but oftentimes it might be a request based on fear, based on intimidation, based on economic dependency, and not based on the best interests of the victim, him or herself, or the children that might be involved, or the community as a whole. And so oftentimes a victim might come in and we might say, well, we have the evidence to go forth, and so we're not going to follow your request. And law enforcement, similarly, they may make an arrest out on the street, which is perfectly appropriate based on their burden of proof, but when we look at the case as a whole, we may say there isn't enough evidence to proceed, and so we may decline to file charges. Just because we decline to file charges doesn't mean that they were wrong, okay? Because they are working on different standards of proof. Law enforcement is working on a probable cause level of proof, which is much lower than our conviction standard of beyond a reasonable doubt. And so just because you might hear somebody was arrested and then you might later see an article saying the state's attorney elected not to file charges, that does not mean that the initial arrest was inappropriate. It might have been. We might have looked at it and said, there's a problem with this search. We might have looked at it and said, there was a problem with the way you interviewed this suspect. It might have been a problem. There might have been something inappropriate done. But it also just might have been that the evidence that you had wasn't enough to go forward. And so it's not necessarily an indictment of law enforcement if we just decline to file charges. So we file our charges based on a reasonable probability of conviction. So it doesn't have to be a lockdown, absolutely watertight case. You know, my staff has to get out there and try some cases that might not be so fantastic because we have an obligation to protect the public. So the question is, are there legally admissible facts and evidence to establish the elements of the offense? So the evidence we have, is it legally admissible? Are there search and seizure issues? Are there issues with the suspect, with an interview? Are the witnesses credible? Are they reasonably credible? Unfortunately, in the world today, most of our crimes are not witnessed by kindergarten teachers and nuns. Most of our victims are not wide-eyed innocents. Many of them are not cooperative. Domestic violence victims, shooting victims. Many of them are people with long histories of involvement in the criminal justice system themselves. The criminal justice system really involves a very small percentage of our overall population, and unfortunately, repeatedly. If you ran the criminal histories of the relatives of the young people in our detention center, the stack would probably be this high. And that might be a reason why those young people are making the decisions that they've made that have resulted in them being in the detention center. And so this is a chicken and egg cycle kind of issue. But our witnesses aren't always terribly credible on their own. And so if there's a credibility issue, can it overcome at trial? Does the physical evidence corroborate the witness statements? So it's not just a statement of a witness. There needs to be corroboration. People just don't necessarily believe somebody with a long criminal history when they get up on the stand and say something. That's just common sense. So we need that corroboration, or independent witnesses. So when the domestic violence victim comes in and says, I don't want you to file charges, if I have an independent witness who saw things happen, somebody sitting on the street who saw something happen across the street, or a neighbor who heard something, or a relative or a friend, that's going to carry weight for us when we make that decision. Okay, so a little bit of law, and then we'll have some audience participation. Misdemeanors. Our crimes are divided into different classifications. So misdemeanors are the lower level criminal offenses. In Illinois, they're punishable by up to a year in the county jail. They are not punishable by time in the Illinois Department of Corrections. Many years ago they were, but not anymore. You can get what's called court supervision for a misdemeanor. And what that means is that at the end of the term of the court supervision, if you've done everything you're supposed to do and you haven't gotten in any more trouble, then the case gets dismissed and you have no criminal record at all. So obviously that's the best result short of dismissal or no files being charged. Whoops. A misdemeanor, you're subject to arrest. You can post bond without appearing before a judge, generally. So if you get arrested for a misdemeanor, you can post $100 and leave the jail without having to go to court. And then you get a notice, you get a date for a date to appear later on. Okay, so except for domestic battery cases. You have to appear in front of a judge if you're arrested for domestic battery. You cannot just post bond and get back out. And obviously there's a safety issue there. Okay, so you have a right to appointed counsel, trial by jury, and some misdemeanors can be elevated to felonies depending on your prior record. So theft, if you have a conviction for misdemeanor theft and you steal something else, it becomes a felony. Domestic battery, if you have a conviction for domestic battery and you beat up your next girlfriend, then it's a felony. This is, think back to raising children. First time you say don't do it, second time you say go sit down in the corner, it goes up. And so same with some of these offenses. I like to throw in that indecent exposure is also one of those crimes for some reason. The first time you expose yourself in public, it's a misdemeanor. The second time, it's a felony. I don't know why. This is the point where we wonder what they're thinking in Springfield. That's just one of those. Okay, so misdemeanors are theft, less than $500, or less than $300 if you steal from a retail merchant. Again, I don't know why. It's different if you steal from Walmart than if you steal from an individual person, but that's what they decided. Battery, domestic battery, lower level property cases, marijuana possession, driving under the influence, those are all misdemeanors. Okay, and so no drug crimes other than marijuana possession are a misdemeanor. Everything else is a felony. Felonies. Felonies are your more serious crimes. They are punishable by imprisonment in the Illinois Department of Corrections, at least a year, up to natural life, depending on the class of the offense. They are also generally eligible for probation, but they are not eligible for court supervision like misdemeanors. Again, the legislature decided some drug possession cases are eligible for what we call first offender probation, which at the end of the term can be dismissed. But otherwise, the only way that you get a felony off of your record is a pardon by the governor. And that is very difficult to get unless you're politically connected, and I didn't really say that. Okay, so a felony conviction stays on your record for the rest of your life. And what does that mean? That means you can't legally own a gun ever, not any kind of gun. You can't go hunting unless you bow hunt. It means there are many jobs that you won't be able to get, and when I'm talking to high school students, I always turn to the teacher and say, for example, there are no felons, convicted felons who are teachers, nursing jobs, doctor jobs, lawyers, security jobs, police officers, all those kinds of employment, probably not an opportunity, if you're a convicted felon. You can vote in Illinois, and again, I always tell the high school students that if you're a convicted felon, you can vote. You are subject to arrest. In a felony, the bond must be set by the judge. So you can't just post $100 and get out. You have to appear in front of a judge. And this is all important in the whole context of our jail population and all of the processes that we've been talking about. So your types of offenses: theft over $500, theft with a prior theft conviction like we talked about, burglary, robbery, aggravated battery, if you hurt somebody really badly, if you cause great bodily harm to them, if you beat somebody up in a public place, if you beat up certain types of people like police officers or nurses or teachers in school, those are all aggravated batteries. Those ones that I talked about, the domestic, the DUI, theft with a prior, weapons offenses. Many of our gun offenses are felonies. Drug possession cases, again, other than lower level marijuana, drug possession cases are all felonies. Sexual assault, sexual abuse cases, homicide, those are all felonies. So, one of the joys of the law in Illinois is that it gives us many choices. So we do not get police reports every morning and stick them in a computer and it spits out, this is what the offense should be. That's what we have people for, who have the opportunity to use their discretion and their experience and their decision making to make those decisions every day about how to charge something. And there are some offenses that could either be a felony or a misdemeanor depending on what decision we make. Okay, so this is the audience participation part. Sammy the steak stealer. And I talk about Sammy the steak stealer when I talk to my high school students and classes and groups. So we'll use Sammy as the example. It is July. Remember when it was hot? Try to think back. Hot. Okay, so it is July, it is hot out, and Sammy's going to have a barbecue. So Sammy puts on a big baggy coat with lots of pockets and goes to Schnucks and goes back to the meat department and puts some ribeyes and some steaks and some chicken breasts in the pockets and leaves Schnucks without paying. Now Schnucks has cameras everywhere, and they've got store security people in the back who are watching, and they go out and they stop Sammy in the parking lot and they call the Urbana Police Department. And Urbana shows up and they arrest Sammy. When they arrest Sammy for burglary. Burglary is a Class 2 felony. It is punishable by from 3 to 7 years in prison. The second time you get convicted of it, it's non-probationable. You must go to prison. The third time, it's Class X, 6 to 30. How could we charge him with burglary? Well, the law in Illinois defines burglary as entering a building with the intent to commit therein a theft. So what is the elements of the offense? What evidence do we have that Sammy entered the building with the intent to commit a theft? Big baggy coat. In July, it's hot out and wearing a big baggy coat with pockets. Oh, I forgot, Sammy doesn't have a wallet. Sammy doesn't have a wallet. What else? What did Sammy do when Sammy went into the building? Didn't shop around, didn't look at other things, went right, because these are all appellate court cases that help us define how to prove entering with the intent to commit a theft. And one of those is not shopping around. So if you enter the building with the intent to shop and then later decide you're going to steal, it's not a burglary. This is the way the judges decide things. So, and let's say when Sammy is stopped in the parking lot that Sammy is cooperative and confesses and says, oh, I was going to have a barbecue and have some friends over and this was a really stupid decision and I shouldn't have done this. So there's another proof of Sammy's intent. So we could charge Sammy with that felony burglary. We also could charge Sammy with the misdemeanor theft. So the definition of theft in Illinois is knowingly exerted unauthorized control over property belonging to another with the intent to permanently deprive the owner of the use or benefit of said property, and it's worth less than $500. So we have those elements, right? Sammy took the steaks, was intending to keep them and use them for him or herself, and so we could charge Sammy with the misdemeanor. And that would give Sammy the opportunity to get court supervision and go on without that conviction burdening him or her through the rest of his or her life. So how do we make the decision? Both are legally appropriate. It was appropriate for the police officer to arrest Sammy for a burglary, legally appropriate. So what else are we looking at? What other things might we look at?
He hasn't had any prior.
Yes, Jan, a huge consideration is prior history. And we run the prior criminal history of every individual that we're reviewing, state, local, and national, if we can get it. Because that's a huge issue. If Sammy has never been in trouble before and made a really bad decision, then we can give Sammy that opportunity to go forward with the misdemeanor. But if Sammy's somebody who's been in and out of the system, repeatedly has had opportunities in the past to make better decisions and continues to steal things, continues to commit crime, then at a certain point we have to act like our parents and say enough is enough and now it's a felony. So that's a huge, huge, huge piece. What other things might we look at? How about Sammy's being cooperative in the parking lot? Or alternatively, Sammy takes a swing at the security guy and runs away and the officers have to chase him or her and it becomes a big fiasco and a huge problem and a public safety issue. Cooperation is a consideration, absolutely. How about we change the scenario? Now it's not steak, let's say it's baby food. Maybe Sammy's stealing because he or she can't afford the food. Or maybe Sammy's stealing baby food in large quantities because he or she is going to sell it on the streets or trade it for drugs. You know, I mean, these are all the reality of things that we see every day. And so these are all kinds of things, you know, that we're considering when we're making these decisions every day. And I just like to put that out there so people can see it's not black and white. There are so many grays. So let's again go back to this example of how things work. What are some of the decision options that the police officer has at that point when Schnucks calls and says we have a shoplifter in custody? Okay, so they can show up, and the first option is community caretaker response. What if Sammy has mental health issues? And we have a lot of people who will go in and just take random things, you would be surprised, because they have mental health issues that are causing them to make these decisions. Well, our law enforcement officers could take Sammy to one of our local hospitals if Sammy's a danger to him or herself because of the mental health issues. And our law enforcement officers are becoming much better trained, again, as a result of this review. We've had a lot of meetings, a lot of discussions about crisis intervention training for law enforcement officers to make sure that we are utilizing our local hospitals and our mental health facilities appropriately. So it could be a community caretaker response, first of all. They could write a city ordinance ticket. Urbana and Champaign have city ordinances, and theft is one of those things they could write a ticket for. And we are encouraging the use of city ordinances as well, because those are things that do not go on someone's criminal history. They could give the person a notice to appear in court for a state offense. And I'll talk a little bit more about, show you some numbers, but that again is one of the suggestions that came out of the ILPP report, is that we increase our use of notices to appear in lieu of arrest. So rather than being taken into custody, taken to the jail, booked in, and going through that process, they're given a piece of paper that says you are ordered to appear in court on a particular date. And that gives my office time to review the report prior to that court date, and gives that person the opportunity to show that they're going to show up in court and follow those court orders. And so that's something, again, that we're encouraging, and I'll show you some numbers in a bit. Let's say Sammy ran away, but they were able to identify him or her. They could come to our office and seek a warrant and have us review the case and make a charging decision without an arrest. And then they can go and get a warrant to arrest the person. Or they could make that decision to arrest, to a custodial arrest. So those are all the decision-making pieces that are in the hands of the police officer at that moment. The arrest decision, as I said, might not be the same as that final charging decision. And that arrest decision sets that initial bond. So even in the decision to arrest, the officer has to decide, is this a burglary or is it a theft? Because if it's a theft, Sammy can post $100 and leave. If it's a burglary, Sammy has to appear in front of a judge. And so we are always encouraging the use of appropriate decision-making by the officer on the street. And this example is one of those where we have to really have had to get them away from always charge it as a burglary to saying start off as a misdemeanor unless you can prove it's a burglary. So those are all pieces of the decision-making process for the police officer. Notices to appear, like I said, this is something that came out of the review and something we have absolutely been encouraging local law enforcement to increase its use of. There are benefits for all of us. There are benefits for them. If they write a notice to appear and give somebody that notice, they don't have to take them over to the jail, sit in line in the Sally Port, fill out all the paperwork. I mean, it can take an officer off the street for an hour or two, depending on what's going on in the jail when they make that arrest decision. It's resource saving for the correctional center. That's well documented if they don't have to book somebody in. It's a lower burden on us because we have a couple of weeks to make a charging decision as opposed to a couple of hours. And again, there's that benefit to the suspect or the defendant to avoid that custodial arrest and show that he or she is willing to follow the requirements and show up in court when they're supposed to. So we took that recommendation to heart and worked with our local law enforcement officers, agencies, and the chiefs have all been very agreeable And some of this is a mentality change for law enforcement, because for them, they're used to putting the cuffs on and taking them in. And now they have to get used to writing a notice to appear and saying, show up on your court date. But in the first 6 months of 2013, they wrote 237 NTAs, notices to appear. And we really started encouraging the use of the NTA in the summer. And so the last 6 months of 2013, we had 348, an increase of 111. So it's 111 people they would have otherwise taken to jail who were given notices to appear. And so we're really seeing an increase in that process, and I think that's a positive benefit.
And of those people who get the notice to appear, did you have a really high percentage that actually did it?
Yes. Yeah, we really have not seen an issue. And because the ones who are getting the notices to appear are going to be Sammy the steak stealer. They're going to be your lower level offenses who are going to show up. And so why not give them the opportunity to show up as opposed to booking them into the jail? U of I Police Department took this to heart absolutely. And so at the beginning of the school year, there's always people who steal books from the bookstore, whether it's because they can't afford it, the books, whatever. And so they were writing notices to appear for every person who stole books at the bookstore. And the bookstore was not happy with this because the bookstore wanted the people who stole to be arrested and taken away. And they had some serious complaints about it. But U of I definitely saw that as an advantage for them. They have low manning, they don't have a lot of people out on the street, and so really a time saver for them and an absolute benefit for everyone. So this is something that we are encouraging. Yes, ma'am.
If they don't appear, then it becomes what?
Then it would become a warrant.
Okay.
So.
Which means they would be arrested.
Right. Yep. And so, that's all on the notice to appear, so they're aware of that.
Okay.
And we really have not seen a huge increase in the failure to appear process.
Can you talk about the criteria used to decide whether a notice to appear is an appropriate thing to do?
Well, each police department's going to have its own criteria, but generally they're going to be looking at lower level offenses, certainly the misdemeanors. They're absolutely encouraging the use of notices to appear rather than arrests for misdemeanor offenses. The police officers have access to people's prior criminal histories, so they're going to look at that as an indicator as well. Nonviolent offenses, lower level type of offenses such as that, property crimes, those sorts of things, are really, I think, what they're starting out with. But each of them are going to have their own separate criteria.
Do you have an idea about how these numbers compare with the total numbers of arrests?
Not off the top of my head, but I can get to another point where there's some other numbers, but not off the top of my head. So this is a benefit and something that we're continuing to encourage. Okay, so, and again, if I'm going too in detail to anything in particular, just raise your hand and say, move on, move on. But I wanted to give you some idea of some of the time frames that we work with when we're talking about the arrest process and the charging process and the decision-making process at the front end of the criminal justice system. So by statute, the first one, a person arrested shall be taken without unnecessary delay before the nearest and most accessible judge in the county. That's what the law says. The U.S. Supreme Court in Riverside defined that as within 48 hours is reasonable. So we have to have a probable cause decision by a judge within 48 hours. Illinois statute goes on to say a person in custody for the commission of a felony shall receive a preliminary hearing or indictment by a grand jury within 30 days. And you can waive that right as well. You could waive the right to being indicted by a grand jury or having a preliminary hearing. But that's supposed to happen within 30 days. So if you're arrested, you're supposed to appear in front of a judge within 48 hours if you're still in custody. If you're charged with a felony, you can waive your right to a preliminary hearing, or you're supposed to have it within 30 days. The U.S. Supreme Court in Gerstein said that the probable cause determination is not a critical stage in the prosecution that requires appointed counsel. So the initial court hearing where probable cause is determined, where we say, Judge, this is what the evidence is, and therefore there's enough to go forward, is not a critical stage in the prosecution that requires by law appointed counsel. So you don't have to be represented at that point. In Champaign County, they are. That's why I'm pointing this out. The law does not require us to have public defender appointed at that first court hearing. And any of you who've been to arraignment court will see public defender is appointed at that first court hearing. So we're not required to do that, but we do. And again, the Illinois Supreme Court in Lang recognized that bond hearings can be held ex parte, meaning without counsel, without even the defendant present. In many counties in Illinois, bond hearings, that point where the judge decides what the bond is going to be, might be just the prosecutor and the judge sitting down at a table. Might be just the judge reading a written statement by the prosecutor. Doesn't have to be a hearing where the defendant is present, where the defendant is represented, where it's a public hearing. It can be completely ex parte, that setting of bond. And many counties in Illinois do it that way. So this is the law. That doesn't mean that's what we do.
Do we have any judges on the weekend at all?
Yes. We have what makes us unique. Good segue, Jan.
Oh, thank you.
In Champaign County, we do daily arraignment court, including weekends and holidays except for Christmas. So that means that the defendants who are in custody see a judge within 24 hours of their arrest. Some much less. So if somebody is arrested right now, they will be in court tomorrow at 1:30. We will have reviewed the report. They will have been appointed a public defender if they want a public defender, and there will be a judge present, they will be present, there will be a hearing. So none of that is required by the law, as I just told you about in the last slide. And not every county, in fact not many counties, do it that way. Like I said, the public defender is appointed at arraignment and bond hearing.
Whose decision is it that you do it this way?
It just always has been. I've been in the criminal justice system in Champaign County for 20 years, and we've always done it this way. This has just always been the way that we've done it. And it moves the process along. You know, in McLean County, they don't do it this way. In McLean County, bond is set without the public defender, and the case is set over for a grand jury, which again, they have 30 days. So a person can sit in custody unrepresented for 30 days before they're arraigned on their charges. And that's appropriate under the law, but obviously creates incarceration issues that result in some of the things that we've talked about. Also unique, in my view and in my discussion with my fellow state's attorneys, is that police agencies in Champaign County provide full reports to my office for our review. So we don't just get a 1 or 2 line summary, you know, saw crime, arrested defendant. I mean, in many places, when I talk to my fellow state's attorneys, they're absolutely surprised that this is the way we do it, but we have always done it this way. It's part of our law enforcement culture. And if I don't get a full police report, I can call and say, where's my full report? And I do have this problem with the state police because they work in so many different counties. And so they're not used to, you know, they are not used to writing full reports. They're used to making arrests and then getting off duty. They're not going to pay them overtime. And then they write their reports when they come back on the next time. And I've had to struggle, you know, with new commanders at ISP to make sure that they're going to get me the full information so we can make those decisions. We review local, state, and national criminal history data. And we have, again, as a result of, well, not really even as a result of, but definitely augmented by the review from ILPP and the discussions that we've been having. But we have mental health professionals available to us in the jail to help us evaluate defendants who have mental health issues and make decisions. And there's constant communication going on between the jail officials and my office, myself personally, when we have an individual who presents in the jail with mental health issues. Because we cannot file criminal charges against somebody that we want to send to the hospital. They will not take them. They cannot take them under the law. If we believe somebody needs involuntary commitment, we cannot have pending criminal charges. And so we may decide not to file charges if somebody needs immediate mental health treatment and needs to be taken over to the hospital immediately. And we have those mental health professionals in our jail. Again, part of this process has been really to augment that, increase the funding for those mental health professionals, which are vital. So that's, again, a benefit that's come out of this process. Okay, so what does the public defender do? Every day, the public defender has an attorney assigned every day to go meet with the in-custody defendants and get information from them for that bond hearing. They talk about their residence, employment, family, ties to the community, their financial resources. Oftentimes, the public defender will say the defendant can post $300. They'll find out what can they come up with. Their mental health history, their physical health, substance abuse, other kinds of issues, and all those relevant issues that go to the question of bond. So they're gathering that information every morning. They go over to the jail. I believe they also have closed circuit television access as well, and they meet with everybody in custody, regardless of whether they're going to be appointed. Maybe the person says, I want to hire a private attorney. Well, they're still going to get that information, because if the private attorney doesn't show up for the hearing in the afternoon, somebody needs to represent that person. And so they talk to everybody who's in custody. We, at the same time, every morning, are reviewing the people who are in custody and the reports. I get an email on my phone at 6:30 every morning. It wakes me up. Who's in custody? Some mornings, it's 5 people. Some mornings, it's 25 people. It really just depends on what happened the night before, and it could be different every morning. So every morning, we're getting those police reports, and sometimes they're still finishing them in the morning and bringing them over as the morning goes on. We get them generally by hard copy, but we are working with the departments to create a process for electronic report transmission, which is going very well, and hopefully will help save some trees and some time. And so then the attorneys in my office take on the initial review of those reports. And again, it depends on what's going on every morning. Could be 5, could be 25. Could need everybody in the office, could need just a couple people. So they review the reports, review the criminal histories, they make a decision about what the charges should be, and then they bring it to me or to my first assistant or to my lead prosecutor for our approval, because that decision is so important. And all the while, we're also managing those special issues. Mental health concerns, medical concerns in the jail, parole issues, warrants from other counties, warrants from out of state, all kinds of paperwork involved with those, and victim concerns. Every day I have a victim advocate who's assigned to door duty, so that when people show up at the door, there's somebody available to talk to them. We don't just say, come back later, or we'll give you a call. And their concerns are very relevant, whether it's, I don't want you to file charges, or I want you to file charges. We need to speak to the victims of the crime and make sure that their voices are heard. And that's just a little information about that mental health process, that involuntary admissions process, where if we have somebody in the jail who we believe needs mental health treatment immediately, we can bring them over to the hospital and file a petition for involuntary admission. We have to be able to show that they're a danger to themselves or others. Many people, when they're brought to the hospital, will voluntarily admit themselves. And so we don't have to go through this process. But if we do have to file a petition, we can do that, and it results in a 90-day commitment order. But we cannot have criminal charges pending when we do that. And we've only had to file 76 petitions since 2010. Some of that is because the hospitals are somewhat reluctant. Sometimes we bring people over there and they say, no, we don't want them. Or they're fine, but they're not really. So that is an issue.
Yeah, I understand. I know at a meeting of police at the mental health board meeting. One of the complaints that the police had is that they making the same point you were making about the fact that if a person is just kind of out there in left field but not eliciting any physical behavior, then they usually don't have any trouble of their being admitted to the hospital. But if it's combative, very often they will refuse, and that's supposedly one of the reasons why the jail becomes the fallback alternative.
Yeah, and or they'll have somebody who is brought to the hospital for mental health reasons and is combative and hits a security person at the hospital, and then they'll call and want that person to be arrested. And so then the problem becomes the jail's problem. There are no easy answers to that. It's a resource question. There are some people who just, nobody has an appropriate place for them. And this is a big community resource issue, not just here, but really any place. What do we do with people who are so mentally ill, that they put themselves in those situations, or that we find them in those situations? Because the jail is not an appropriate place for them, and certainly not the current standard of jail that we have. Okay, so here's the part you all wanted to talk about. Pretrial Services Test Program. So I've talked about a number of things that came out of this report and the evaluation and the process that we've gone through that have been very positive for all of us. And there are lots of other things. The sheriff wrote a letter to the board where he listed all the kinds of things that he's doing in the jail now differently as a result of the discussions that we've had with Dr. Kalmanoff and with each other over this time frame. And one of those recommendations was pretrial services. And so we in the justice system decided to try pretrial services the way it was outlined in the report, or a bit. I mean, we didn't necessarily, there are some things about the way that it was suggested that we felt didn't mesh with our current system and would only slow us down. So for example, when I talk about how we make those decisions within 24 hours, if you're arrested today, you're going to be in court at 1:30 tomorrow. The way that pretrial was suggested, we felt would have slowed us down if we tried to do that evaluation on everybody who was in custody on a daily basis. There would have been no logistical way, if we had 25 people in custody, to do the evaluation the way they were suggesting. So what we decided to do was to look at people who had bond set and were still in custody after arraignment court. And we also decided to limit it to people with bonds set at lower than $50,000, because that's a pretty good threshold for danger to the public. So if your bond was higher than $50,000, you weren't part of the test process. Every day, the public defender would look at which defendants were appropriate for the program and go and talk to them and make sure they wanted to do it, because we couldn't force somebody to be part of a program they didn't want to do. And if the person consented, then the PD would get a court setting within 2 weeks from the judge so that we could go through this process of evaluation. And the court services officers, probation officers, would assess the defendants using the Virginia Pretrial Risk Assessment Instrument, which was recommended by Dr. Kalmanoff. They would also do a criminal history review and verify things like residence and jobs and employment and school and substance abuse history, all of those things that were part of that process. And then the court would make a determination based on the report that court services would give using that risk assessment as to whether or not to decrease the bond in order to allow the person to get out, and also could require additional bond conditions such as GPS monitoring, substance abuse treatment, no contact orders, random testing, that sort of thing, all of which was recommended in the report. And so we decided we were going to try this. So here is the data, and I hope you can see this. In the 5-week time frame that we looked at, we had 422 cases total in arraignment court. So that means 422 people were either arrested or came into arraignment court during that 5-week time frame. Out of those, 238 were in custody. So about 200, a little less than 200 of them came into court not in custody, meaning they were the people who had posted bond, the misdemeanors who had posted bond, or were notices to appear, or that sort of thing. Okay, and so they were not in custody. So there were 238 people in custody. 55 of them were released from custody in arraignment court. So when you go to arraignment court, the prosecutor may recommend release the person without them having to post bond. That's called releasing them on their own recognizance. Okay? We could say, looking at their history, we don't think they need to be in jail. We agree, release them on their own recognizance. Or we might have decided not to file charges, and so they got released. So 55 of them were out of custody. 53 people who came into arraignment court in custody had their bond set in an amount that they could post within 24 hours. So there's another chunk, 22% of the original 238. They're out. 36 of them had bonds set greater than $50,000. So not a whole lot had high bonds, but these are going to be your more serious cases. So 15%. 52 of them who were in custody had parole holds from the Illinois Department of Corrections, meaning they were on parole and committed another offense. And so parole issued a hold saying we're taking them back to the Department of Corrections. Or they had warrants out from other counties or other states. And so they didn't qualify for the program because they had other obligations other places. So that's 52, 21%. 9 people told the public defender, I don't want to do this, or I can come up with the money. So they refused to participate. So that left us with 34. So 34 people, we told over the 5-week period, told the probation department to start the process, start doing the evaluation, meet with them, do the Virginia risk assessment, etc. In that time frame, 25 of those 34 cases were resolved because my staff is making offers and saying, if you plead guilty to your offense, this will be, here's the agreement. It could be time served, it could be, a variety of different things. And 25 people resolved their cases before completion. 6 people posted the bond while they were being evaluated. That left us with 3. So we had 3 hearings for pretrial release. In 2 of those, we found out one guy was on probation and hadn't done anything he was supposed to do on his probation. And so the judge denied his request for a bond reduction. And the other one, we found out had some significant similar crimes in California that we did not know about when we had initially charged him. And so the judge again declined to reduce his bond. So we had one individual whose request for bond reduction was granted, and he was released and was monitored by court services. But I do want to point out that we had made an offer for that individual for probation and no jail time, which he ultimately took. So essentially his case was resolved as it had been offered. So these were the numbers that we had, and people have asked, why did you only do this for 5 weeks? Well, it wasn't planned that way. The reason why we stopped was because the county board was making decisions on the budget. And the county board had set aside a large chunk of money, put it into court services line item for staff, to hire staff to run this program. And the judges, and we all felt that it was money that was not going to be best spent. And rather than having it end up in court services line item, we'd rather say no thank you use it better someplace else. And that really was the decision-making about the time frame. It wasn't, let's do it for 5 weeks. It was, okay, they're going to vote on the budget. We don't think this is something that needs to be in the budget. But we can debate whether that's right or wrong or whatever, but I'm just letting you know this was the perspective. The numbers don't really bear out that we need this kind of a program or that we need to spend money, because really essentially what we're doing already is the same as what is being suggested in the program. The information that we provide to the court, that the public defender provides to the court, is the same information that the model pretrial program provides, other than the last one, the instrument score, which basically takes all of this information together and gives it points. And quite frankly, Dr. Kalmanoff would say, well, you know, if you release somebody and they end up doing something, you can always say, well, the point system said. I don't work that way. I'm not going to hide behind a point system. We make our decisions based on the information that we have, and we stand by our decisions. And so we did not feel that a point system was something that was somehow going to magically help us make different or better decisions. And again, I think that's borne out by the numbers. You know, when you see that people are posting their bond within 24 hours, that their cases are getting resolved, that there's a relatively lower amount of people who are being held on high bonds, that all supports that the decisions that are being made at that bond setting are consistent and appropriate.
I'm confused because I thought the risk assessment tool that Dr. Kalmanoff was talking about was a way to determine who could be let out on their own recognizance and who would be as part of the bond, setting
Right.
the bond. So it sounds like, so then how are people posting their bond before that has even been determined?
Because what happens is that and you can come to court at 1:30 every day to see arraignment court. And what happens is that staff from my office, the assistant state's attorney, is going to stand up and tell the judge probable cause, which is basically a little summary of what the evidence is. You know, if this case were called to trial, the evidence would be that the defendant was seen going into Schnucks wearing a big baggy coat, going back to the steak department, putting the steak in his or her pockets and leaving the store past the points of payment without paying, was stopped in the parking lot, had the steaks in his or her pockets. And essentially that would be the evidence. And then they're going to give the judge a history of prior criminal history. The defendant has no prior criminal history. The defendant has previously been convicted of this and this and this and this. The defendant is currently on probation. The defendant is on parole. They're going to give the judge all that information. The public defender is then going to stand up and say, my client has lived in this community his or her whole life. He has 3 children that he's supporting. He works at Plastipack. If he doesn't show up for work tomorrow, he's going to get fired. He's able to post $300 bond. If you set the bond accordingly, he'll be able to post that. And then the judge is going to take all of that information and make a decision. And probably if the public defender said he can post $300, then bond would be set at that amount, you know, unless it was a much more serious offense. That's all the information that goes into the risk assessment tool. The difference is that the risk assessment tool spits out a number at the end that is on a scale to say this person is a risk to reoffend or to not appear in court. But that's the decision that the judge is making with that same information, just without a number. Does that make sense?
Yeah, but then it doesn't really make sense that you came up with, how many people? 3 people that you did the risk assessment, but you'd already kind of done it. You know what I'm saying?
Right, but that's what I'm saying. Because we have already done it, and so a lot of people already posted the bond that was appropriate for them
Okay.
or resolved their cases.
If you go back one slide.
Mhm.
No.
This
go-
one?
Yeah, that one. So what you're saying are you saying that the way that the system currently works functions appreciably like
Yes.
an assessment? That you already had all those things in place, you just weren't calling it the Virginia or whatever, and it wasn't actually done on paper and scored in a particular manner, but in fact, the system that you currently have assesses people based on the same criteria?
Right.
Okay.
And our judges were absolutely adamant that they were not going to say, well, this person's a 7, so therefore I'll set bond at X. You know, they were not going to be bound to a number system.
So we're not missing any information by not using that instrument, except for
No.
that score?
Right, and you know, and one of the pieces of discussion was, well, if we do this, we can verify the information that the defendant gives to the public defender's office. So when the public defender stands up and says, my client says he works at Plastipac, do we believe him? Well, and the judges would say, yes, I believe you when you stand up and say that. It doesn't, not going to give it more weight if, now it's certainly if they call Plastipac and they say, no, that guy doesn't work here, we've never heard of him before. That's not going to be helpful to the defendant. And so the judges didn't find the verification process to be all that helpful.
So I'm trying to understand this. It sounds as though you're saying you don't need to test the Virginia standard because you don't need to use that process because you already have a process.
Yes.
But how can you compare what results you would get, whether the results you get would be different if you actually did use the Virginia standard to the results that you get by just having the judges make their own decisions? Because maybe they would be different. I mean, wasn't that the argument that the LPP was making? That's the reason that you should be trying the Virginia standard, because it might give you different results than the ones you're already getting.
Yes, but again,
Even if it has the same information as input, it might have different weights on it, right? You know, if you did use that standard, then you might be able to compare, for example, the distribution of bail that gets assigned for defendants here than those that would be assigned for places that are using the Virginia standard, right? Which you can't do now because you're not using it.
I'm not entirely following your question, but what I can tell you is that Champaign County does not have an overcrowding problem. Generally, the jurisdictions that are using the risk assessment tool have an overcrowding problem. We don't have that, and I think these numbers really do bear out that the decision-making that we're making at that initial stage when it comes to setting bond is appropriate, and that we don't, and again, I'm trying to speak for the judges and the other court personnel who are not here, you know, but that generally we believe that we're making proper decisions when it comes to setting bail, and that this process bore that out. Because again, you started out with 238 people in custody, 23% of them were released immediately. A quarter of them were released immediately. Another 22% of them, whatever bond was set was appropriate enough that they were able to post it within 24 hours. So that was appropriate. Only 15% of them had bonds greater than $50,000. That means there was a small percentage that were very serious, and a large percentage who were able to post the bond that had been set. 52 of them, 20%, had other issues that prevented them from being able to be released anyway. Again, a significant factor. You know, so if you go down the list and you look at the numbers, in my view, that supports that the decision-making that we're making at that initial stage is appropriate. I'm gonna go there and then there.
It would seem that one of the reasons, you go at it, you have a systematic decision-making process. Now, I can imagine in some other counties they would not have that process. And they have a standardized tool would mean on a statewide basis, you might say, there'd be at least some consistency from one area to the next. But on the other hand, if you do it, then you have to go through an extra step of using an instrument, this kind of thing. It might say, well, I can understand the thinking. You can say, well, that just takes more time.
Mhm. Yeah, and that really was a big part of the decision-making, is that it would slow us down. You know, if we had to, because my office is going to review criminal histories. We have to in order to make that charging decision. We have to know if somebody has prior convictions for a certain type of offense or what their prior history is. We have to know that. So we're not going to give that over to the probation department to do in order to, you know, to do this risk assessment report.
No,
And-
sorry.
No, that's okay.
I was kind of wondering if in the process of developing this instrument, if they ever made a sort of comparison between people who use them and people who don't. And for instance, if my guess would be that in your case, the results would be very similar because you have a data collecting system which is approximates what's on that scale. The only thing you don't come up with a score, but you come up with some criteria for making a judgment. Sometimes you need some kind of a validation thing where you compare if you make one decision like you do and you use another using the standardized instrument, and if they come out both the same, it implies that the system you're using is equivalent.
Yeah, I agree, and I think it would be an interesting exploration to sit down and, you know, go through past cases and score them out on the data sheet, on the instrument versus the decision that we made, and see if we were correct. Again, the criteria for bond setting and the criteria that's explored on the instrument is really the two important points of bond setting. Whether you're a risk to reoffend, a risk to the public, or whether you're a risk to fail to appear. You know, that's what the risk assessment tells us. It scores out a number based on those two criteria. And that's what the judges are looking at, or what we're looking at when we're setting bond as well. Is the person a risk to reoffend or commit further offenses while they're out on bond? And is the person a risk to not appear in court? And so, yeah, it would be an interesting test to go through that process.
A validity test is to test two different circumstances. If they agree, they're equivalent. If they don't, then there's something awry somewhere.
Yeah. But really, what this came down to was the court system, the judiciary essentially, because they were the ones making the decision, and the money was supposed to go into court services, which is a part of the judicial branch of government and the judicial system, basically saying, no, we don't believe that this is money well spent or necessary at this point compared to where it could be spent in other places. You know, so really, I want to make sure that, again, I've tried to bring up a bunch of different things where we've found value to this process and where we've worked it into our current system and are continuing to work it in, because there is a lot of value in this report. But this was one thing that we tried out and, quite frankly, we thought didn't fit into the system in Champaign County.
You know, going back to what the report had said, which they used as a reason for why we would need a pretrial system, the fact that when they did the tracking, that pretrial detainees comprised 80% of the jail population, and then that their tracking study also showed that the vast majority of offenders committed infractions and misdemeanors and spent less than 3 days in jail. So can you kind of address that at this point?
Well, and that's part of, you know, some of the changes that we've made. The notice to appear process, where that's going to reduce the number of misdemeanors and low-level people who come in. And when you're talking about less than 3 days in jail, so if you're arrested tonight and you show up in court tomorrow, that's 2 days. So you're going to get credit for 2 days for having been in overnight. And so, yeah, if you're arrested on a misdemeanor, or if you're arrested, let's say you're Sammy the steak stealer and you're arrested by the police officers on a burglary, and we decide to charge you on the misdemeanor theft and let you out, you're going to have been in for 2 days. And the risk assessment tool isn't going to help us make that decision, is really, you know, the bottom line of that. Yes, the vast majority of people in custody in a local county jail are pretrial. Because again, remember, misdemeanor sentences are the ones who misdemeanors are the ones that are serving sentences in the county jail. And that's not going to be a large population. Some felonies up to 180 days, but generally the misdemeanors are the ones serving time in the county jail. We also have much more flexibility with the use of electronic home detention for sentences as opposed to for pretrial. There is legislation currently proposed to increase the use of electronic home detention for pretrial, but the sheriff has much greater flexibility in deciding to put people out on ankle bracelet monitoring when they're sentenced than pretrial. And
may I please have your attention? The Urbana Free Library will close in 30 minutes. Patrons who wish to apply for or renew library cards should come to the circulation desk in the next 15 minutes.
And so most people, many people who are sentenced, particularly in traffic cases, we have a number of traffic offenses where there's a mandatory minimum jail sentence. That's what the legislature set up. But the sheriff can make a decision to put those people out on electronic home monitoring rather than hold them in custody. And we have generally between 40 and 50 people who are sentenced out on electronic home monitoring in those kinds of offenses. And so that's a significant chunk of the population right there as well. So
Just one more question.
Yes.
The court service, well, it sounds as though the program under question is almost exclusively connected with decision-making about decision to imprison or something like that. Was there any other services that were incorporated in that, or is it just that assessment process?
Well, and then there would be monitoring after that. So if somebody was released, the judge could order that they have to report to court services, that they have to do random testing to determine whether they have been using illegal substances, to recommend them for services, for substance abuse treatment or that sort of thing. So there was a whole monitoring component also, which I think I expressed many times some concern philosophically for, because look at it this way. If you are a drug dealer who is caught driving drugs between Chicago and Mexico on I-57, and you get stopped and you've got a lot of drugs in your car, and bond is set at $500,000, and somehow you come up with $50,000 cash to post, and this happens all the time in these kinds of cases. So you post your $50,000 cash and you're out of custody with no requirements other than that you appear in court the next day, and oftentimes they don't. So you've got the money and you post the money and you're out. But let's say you're Sammy the steak stealer and bond is set at $5,000 and you can't come up with $500, and so we go through this process and we put you on a program, and you have to appear, and you have to do random testing, and you have to go to counseling, and you have to do all these kinds of things, or else we're going to revoke your bond. Well, you couldn't come up with the $500, although that person could come up with the $50,000. That's all I have to say, right? I think that if we had a pretrial program that required monitoring of everyone, that would be fair and helpful. Because I bet the drug dealer is probably using drugs just as much as Sammy the steak stealer might be. But, that's going to cost us a lot more than $200,000. So, that honestly is a philosophical concern that I had about that sort of a process. Because it put requirements on people before they had been even convicted that other people didn't have to abide by simply because they could come up with the money.
Thank you.
Okay, So, these are things that we concluded. We think we go faster than this program would have allowed us to go. And we don't want to slow down. We think we have the data that we would have gotten. We're very happy with some of the things I pointed out, including the increased use of notices to appear, many of the other things that I've talked about. We work very hard amongst ourselves to monitor our pretrial population and communicate and make sure that we're making right decisions and we're moving our cases along and we're making sure people with medical and mental health issues get the help that they need. And so we don't believe this is the best place to spend tax dollars. We think it can better be spent elsewhere. The program that was approved recently for services for people coming back or getting out of jail, that's something we absolutely support. And there's lots of ways that we can spend our tax dollars. And I didn't put it on the slide, but I will say that the jail issue that we brought to the attention of the county board is a facilities issue. We can decrease the number of people down to the bare minimum, but the problem is that in the satellite jail, it is not laid out to be able to address the needs of those that we have to keep in custody. It just simply does not have the facilities, the space for those who have mental health issues, who have medical issues, for those who can't be with other people, co-defendants, gang members, people who have been fighting and feuding in the jail, people who are behavioral risks in the jail. They have to be kept separate, and there are no spaces in the satellite jail to keep them separate, so they have to be kept at the downtown jail. And that means 2 buildings, and that means increased costs, and that means an inadequate facility in the downtown jail, and it means a problem that has to be solved.
Yeah, I think that was another question I was going to ask you. This whole process started with the idea that probably needed a new jail or something like this, and then the results seemed to be that there were enough problems in the processing system, problems with the relationship among agencies in the community and all these kinds of things. And the effort has gone towards developing that. Now, is the jail thing going to come back to bite us?
In my opinion, the jail thing has not gone away.
Okay.
It's just, quietly been ignored, the facilities issue, but it has not gone away.
So that's the second chapter.
Well, it's like everything. I mean, you look at the Champaign School District, they're talking about having to put classes in, temporary buildings outside. And, I mean, buildings change, and the use of buildings change, and the population changes. And, we have to make some decisions. They're tough decisions. And that's not to say that we do everything perfectly. And that's not to say there isn't benefit to all of these programs and all of these discussions that we've been having. There absolutely is.
Well, I think one thing I should commend you with is that there was a time, I've been in mental health for a long time, but there was a time when the mental health people said, well, all they want to do is lock them up and throw away the key. And then the other side said, oh, these are a bunch of, kind of goody two-shoes people who don't have realistic notions about the behavior. And I think the collaboration between your office and the mental health board and community elements has been, and Prairie Center has been really given a chance to work many of these issues out regarding the system of services.
Yes, and everyone has really worked on that, not just my office. I mean, really, the one of the greatest benefits that we have in Champaign County, I truly believe, is a very cooperative system. Law enforcement, court system, we really are all working towards that same goal.
You mentioned, speaking of mental health, you mentioned earlier that there is access to mental health professionals in the jail.
Mm-hmm.
Can you say how much time? Is this a single person, 2 hours a day, 3 days a week, or what? You know, you mentioned they might have to be assessing 25 people coming in over a single night. How does that access work?
There are, I don't know exactly their entire schedules, but there is somebody there is a contract that the county has with Community Elements to have an individual in the jail on a regular schedule, so 40-hour work week. And then there is also the contracted private services that the sheriff has. And he actually told me the other day that they had let an individual had been released from jail and came back and said, you know, he had been working with Nadia, the lady who works in the mental health area in the jail, while he had been in custody, and had established this great relationship with her and wanted to keep coming back and working with her. And so they were working that out to make sure that that was going to be able to happen because it was good for him. And so, and they really are, you know, quality mental health professionals. And so I don't know exactly the hours, but I know that we at least pay for one full-time person from Community Elements, and then the part of the contract for the medical and mental health.
Is that relatively new?
The Community Elements person, yes. That's all came out of this process.
The downtown jail is just so horrible. You mentioned the satellite is inadequate, you know, to separate these various categories. But if a new pods were added, could it be built in a way to be able to serve those?
Yeah, I think that's the thought. You know, in the satellite jail, there's one classroom. You know, we talk about all services and that we want to provide to people who are in custody. We have one classroom. That's not enough. It's not big, and you know, you can't mix men and women, and so you can't, you know, provide GED services. You can't provide, you know, all of the classes that you might want to provide. And the issue of segregation is really important because the only single cells, the only segregated cells that they have at the satellite jail are the booking cells. And so you have to keep people who have to be segregated, and those are generally the mental health and medical people in the booking areas, which is right there in front of everybody. There's no privacy, there's no, it's not what those were meant for. So either they're there or they're at the downtown jail. And so those are issues that just aren't going to go away, no matter how few people we have in custody.
Well, it's interesting to hear you talk about the misdemeanors because your predecessor had record of having the highest number of felonies.
Yes.
I think in the state, and I was on local grand jury. I think that was 2002 or somewhere in here. And it was very frustrating because they present those to you so fast. But it would be a misdemeanor, and then they'd add, I can't remember what the term is, aggravated.
Right.
And some of those, I think we did turn down. Just like the one I remember particularly was a Spanish-speaking person, probably didn't understand what was happening. It was not really an assault, it was some kind of altercation. And if he had stayed on the porch of his house,
right, then it would not have been a public place.
But he went inside, it was on the other side of the screen door, and they wanted to make it a felony.
Yeah, and that's all that decision-making process. I think you missed my first half where I talked about a lot of that.
I went to the Champaign library, I apologize.
No, that, oops.
I think that's all the questions that we have, and we'd like to thank you so very much for joining us this evening. This has been a very informative presentation, and we appreciate all the time and effort that you took to give us so much good information. So thank you.